Welcome to U.S. Immigration TV. Well, many people believe the only way to bring family members to the U.S. is through a family petition. This is wrong. Family can petition other family members through an employment-based petition. In fact, in many cases, as long as the requirements are met, it is faster than a regular family petition. For example, petitions by siblings or married children could take up to 20 years. Now, I want to assure you, it is perfectly legal and is recognized by the U.S. government that family can petition family for employment-based petitions. Now, in this video series, I will show how it is legal, go through what the requirements are, and finally, answer viewer questions. Now first, as far as it being legal, let's examine it. One of the proofs or evidence is the ETA 9089. That's a Department of Labor form, which is the labor certification application. One of the questions asks, is there a familial relationship between the owners, stockholders, corporate officers, incorporators, or partners and the alien? So right on the very form itself, it's asking, is the alien or prospective worker related to the employer? If it was illegal, why would that question be on the form? And of course, the answer would be yes, if you are petitioning a relative for an employment-based green card. Another item to think about is the Affidavit of Support, Form I-864. Now, ordinarily, in every family-based case, an Affidavit of Support is required, but not in an employment-based case, except if a family member is petitioning another family member for an employment-based green card, or if a family member has at least 5% ownership interest in a company. In fact, in the instructions for the Affidavit of Support, it says who needs to submit a Form I-864. And the answer is, among other things, employment-based preference immigrants in cases only when a U.S. citizen, lawful permanent resident, or U.S. national relative filed the immigrant visa petition, or such relative has a significant ownership interest, 5% or more, in the entity that filed the petition. So if it was illegal for family to petition family for an employment-based petition, why would there be a requirement to submit an Affidavit of Support? In fact, on my television show, weekly immigration show, Citizen Pinoy, I have featured several success stories involving family petitioning other family members for an employment-based green card. For example, in one case, I had a situation where a sister petitioned her younger brother as her office manager in her dental office. Another case, an aunt petitioned her niece to work as a caregiver in her care home. Another situation was where a niece petitioned the aunt to work as her housekeeper, so enabling the niece to be able to stay at work at her high-paying job while the aunt stayed at home and did the chores and made her life easier. All of those cases were approved. All of those cases, we declared that the employer and the employee were related, and it didn't have a problem with it. Now, of course, as an attorney, I cannot guarantee results or approvals, and each case is different. But I want to make it clear to everybody who never knew about this, family can petition other family members for employment-based green cards, and if all the requirements are met, the case can be approved. Now, in my next video, I will go through some of the basic requirements necessary in order for a family member to petition another family member for an employment-based green card. So make sure to watch that video as well as my other videos, and be sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.